Hello there, my name is Gorry. I'm a solicitor, and this short video about industrial relations law in Ireland might be helpful to Irish employers in particular. Firstly, you must understand that generally in Irish employment law, the contract of employment between the employer and the employee is the basis of the deal or agreement. However, it can occur that many terms and conditions of employment are negotiated on a collective basis between trade unions and employers, but this may well not happen if you are a small employer and the union is not present in your workplace or your employees are not unionized. So what is the legality, as it were, of collective agreements then in Ireland? Well, the test is, and it's been tested quite often in case law, in High Court and so on in Ireland, is did the parties intend to create legal relations? And each case then will be judged on its own merits. A particularly important case here in this regard is O'Rourke versus Talbot, Ireland, a 1984 case, which you can read about on my website, businessandlegal.ie. You'll see the web address at the end of this video. Individual contracts of employment, they can be altered and negotiated unless individuals have made it clear that they will not be bound by the outcome. What I'm saying there is that the contracts can be altered through collective bargaining or trade union negotiation, provided employees have signed up to the union and are prepared to be bound by any changes that have been negotiated on their behalf by their union. An employee then has a constitutional right to join a trade union. However, an employer does not have to negotiate with the union. In other words, the right to join the union does not follow from that the employer must enter into negotiations with the union in relation to that employee's contract of employment. The Industrial Relations Acts then, there are various Industrial Relations Acts which provide mechanisms for resolving trade disputes, and there are various bodies then, for example the Labour Court would be instrumental in trying to bring about a resolution where there are industrial relations disputes. Many workers then are not actually covered at all by the Industrial Relations Acts. For example, Gardaí, members of the Defence Forces, teachers, officers of VECs, they have their own conciliation and arbitration schemes which go back quite a number of years. An employer can make a mistake insofar as he does not or she does not have to negotiate with a trade union acting on behalf of an employee. That is, unless there's a custom and practice or agreement to do so in that particular workplace. This is why small employers need to be careful about setting such a precedent in respect of negotiating with a trade union if they've not already done so. So, if an employer gets a letter from a trade union seeking to enter into negotiations on behalf of a particular employee, if the employer has not already acceded to or through custom and practice negotiated with that union before, well then there's no reason to do so now if that's the employer's decision. You can get more free information about employment law in Ireland at my website, businessandlegal.ie. If you want to contact me, you can do so with the number you see on the screen there, or you can email me, terry@businessandlegal.ie. Thanks for watching.